State versus Ebenezer Byrd, State versus Jerry Spraulding, State versus Gregory Jean-Baptiste. May we please have appearances of counsel?
Stephen W. Kirsch, designated counsel for Mr. Byrd.
Andrew R. Rose, designated public counsel for Mr. Gregory Jean-Baptiste.
Good afternoon, Assistant Prosecutor Melissa Kerrigan on behalf of the state.
David Engel, I'm the Deputy Attorney General on behalf of the Attorney General.
Welcome, counsel. And I know we have three representatives on the public defender side of the aisle. I hope that you coordinate and adopt arguments that have been previously made as we proceed. Mr. Kirsch, go ahead.
Good afternoon, Your Honors. May it please the court. I'll ask for 2 minutes of rebuttal if I may.
That's fine. Thank you.
Whenever a judge goes to conduct a voir dire, having been given information that there's an irregularity of some sort in the jury, the case law is really, really clear that that inquiry has to involve what the appellate division has called in Scherzer a probing inquiry, or what this court in RD and Lofton and Bay, has called an inquiry into the specific allegations. In other words, specificity of questioning is required when asking those questions. Now, in this particular case, this judge gets allegations which include a number of things, but the most serious one is that this particular juror has pre-decided the case, is going to find them all guilty and burn them. Now, did any of the questions that were asked go anywhere near that allegation? No. The questions that were asked were that voir dire that took place weeks ago, because this is a long trial. Any of your answers change to those questions? Second question is, and that was asked twice, but the second topic is, have you run across any articles or postings about the case? That barely touches on the Googling aspect of the allegations. And then the final one is, can you be fair? You can't be more generic than that. Oh, I'm sorry.
I hate to interrupt you,
Yeah.
but I noticed you didn't reserve 5 minutes. I've got a number of questions, but I don't want to interrupt your flow. So you let me know. Oh, you did reserve 5 minutes.
I did not.
Oh, I'm sorry.
I did not. And if you want to interrupt me, please.
Could I? So RD is different than this case.
Yes.
In RD, we have a juror notifying the court immediately after a witness testifies that the juror knew the witness and can no longer be fair and impartial. The type of information that the judge in this case got was in a roundabout way. It was completely different than the notification that the RD juror gave the judge in RD. And of course, we know in RD that the court also said that if the judge wants to question the remaining jurors, it should be left to the sound discretion of that judge. There should be no per se rule. The questions that I have for you go to what factors a trial judge should consider when receiving mid-trial allegations of juror misconduct. Okay, I can think of two factors, and you touched on one of them already, and I want to ask you about both. First one is seriousness. Clearly, if there's a serious allegation of misconduct, the judge better do something about getting to the bottom of that allegation, right? Okay. Another factor that the trial judge should consider, and of course, we're talking about judges who are in the midst of the trial. This one went for 10 weeks. They have the feel of what's happening during the trial. A factor for a judge to consider when determining how extensive the questioning at sidebar or wherever should be is whether the allegation is reliable or credible. Am I right about that?
You are.
Okay,
But
so I know you're going to say that in this particular case, even though we have an anonymous allegation from an anonymous individual, there's a way to corroborate that, right? Because in the information that was reported, the juror's name was used. We know where the juror worked, and we know where the juror lived. Of course, all of that information is information that comes out anyway during the jury selection process when you're going through the voir dire questions. So in this particular case, and I do want to get back to whether you think there are more factors for the trial judge to consider besides the serious nature of the allegation and the credibility of the allegation. I want to find out from you eventually if you think there are other factors also to consider. Can I focus with you right now on the credibility of the allegations in this case? We have a situation where somebody named Miss Worthy.
Well, can I interrupt you just for a
Absolutely.
second, just to respond to a little bit of what you said?
Yes.
And then obviously we can take this anywhere you want to, but to me, the major factor is really a singular one, but it encompasses both of the factors that Your Honor talked about, which is the capacity, if true, of this allegation to affect the jury, the impartiality of the jury.
Right, but it has to be reliable, right?
Of course, and that's part of it.
Okay.
That's certainly part of the capacity
That's-
analysis, and also the seriousness of the allegation is going to be part of the capacity.
I agree
So
with
I'm agreeing with that. Now, if you're talking about just the reliability of this, then I'm sorry, Your Honor was about to ask me a question.
Right, and this point, and in these questions that I have for you, I am focusing solely on the credibility, the reliability of the allegation. We have a situation where Miss Worthy, we don't really know who Miss Worthy is,
Right.
contacts somebody at the public defender's office, Stephanie,
Right.
and says that a friend of Miss Worthy somehow received information,
Well, works with the juror.
who works with the juror, somehow conveyed information to Miss Worthy that the juror was engaged in this wrongdoing, right? Okay, so Miss Worthy didn't contact the court.
Right.
The individual who works with the juror didn't contact the court, right?
Right.
The people that she worked with, who allegedly she was talking to, never contacted the court.
Correct.
So instead, what we have is double hearsay to Stephanie. I'm sorry, to Stephanie at the public.
Stephanie's public. Yeah. That's the person who took the call.
Right. And then that individual did not contact the court either. That person contacted a secretary for one of the defense trial attorneys, right?
Well, actually, that person didn't contact the secretary. I believe another person in the public defender's office initially contacted the secretary, who then called the judge's secretary.
Oh, because that's not in the emails that I've reviewed in the record. But let's say that's the case. The call goes to Stephanie,
Right.
who then talks to somebody else in the public defender's office, who then contacts a secretary for one of the trial attorneys. That secretary for one of the trial attorneys presumably talks to the attorney, and then that secretary, not the attorney, contacts the secretary for the court, for the judge,
The judge, right.
who then contacts the court clerk, who then notifies the judge that something is happening at 12 o'clock in the afternoon. The court clerk goes back to the secretary for the judge, who then calls Stephanie.
No, the court clerk calls Stephanie.
Actually, I think there was a subsequent email that corrected that mistake. At first, it was the court clerk who we thought contacted Stephanie, but I believe the judge's secretary corrected the email to the court clerk by saying, I meant to say, I contacted, but either one, either it's the judge's secretary or the court clerk's secretary contacts Stephanie, not the person who contacted the secretary for the trial attorney.
Well, I think the reason is because Stephanie took the call,
Okay.
the initial call from the tipster.
And learned from Stephanie more about this alleged misconduct, who then put all of this in an email and gave it to the judge right before lunchtime, right?
Okay.
Okay, so now we're talking about credibility of the allegation. We know it's serious, but we also have to balance in exercising sound discretion during the trial, how far the trial judge should go to get to the bottom of what might be very serious allegations.
Well,
And the judge, I'm sorry, go ahead.
the first, and I was going to talk about this later because I think it's to some degree interesting in terms of future cases as well. But the way this information was gathered was really less than optimal. I mean, if you compare it to Wakefield or to Lofton, in those cases, in Lofton, I believe the judge directly called the person with the information. In Wakefield,
Did
I
Ms. Worthy
believe
leave a phone number such that the judge could have called her?
I'm sorry,
Did Miss Worthy leave a phone number such that?
I
the
didn't mean
judge
calling
could
Miss
have-
Worthy. I meant calling the contact was Stephanie. In other words, the person who took the call.
I understand, but did Ms. Worthy leave a phone number
I don't-
such
I don't
that
think-
anyone could call her back
I
and
don't-
ask follow-up
I
questions?
don't think she did.
Did she identify the friend that worked with juror number 8?
By name, I don't
Yes.
think so. No,
Okay.
no, but identify juror number 8 by name.
We agree that it's less than optimal, the way the judge learned about this.
Less than optimal, but then the way that the conversation with Stephanie ultimately took place is really less than optimal too. I mean, compared, for instance, to Lofton and Wakefield. And what I was going to say about Wakefield was they actually took the Stephanie equivalent in that case, who was someone who worked for the prosecutor's office, brought her in, which wouldn't be hard to do. Monmouth County Public Defender's Office is right down the street from the courthouse, put her on the stand and asked her questions about this and evaluated the credibility of what she was saying she heard.
And that's what I'm getting at, that the trial judge has sound discretion about how to handle the allegations that the trial judge learns mid-trial. So let's talk about how the judge actually dealt with it. The judge called number 8 to the sidebar. And first of all, make sure that all of the questions to the jury voir dire for the jury selection process, all of the answers to those questions are the same. That was a good thing to do, number one, to make sure that at least all of the responses to those questions haven't changed. And the juror says, no, my answers haven't changed at all. Then the judge gets right to one of the specific allegations about whether she was Googling and says, okay, and in terms of any posting or newspaper articles, is there anything outside of what's been in this courtroom that you have been in contact with? And the juror says, no. That was a good question. Very important answer. Then, so is there anything that would change any of your answers to these 28 questions?
Well, that's the same question that was asked
Okay,
first.
he's double checking to make sure that everything is okay. And she says, no, nothing will change. Then he verifies that she can listen to the evidence in the case. She can listen to his jury instructions, which, by the way, the preliminary instructions that the judge gave right after the jury was impaneled were very detailed about not Googling, not checking the internet, making sure you don't talk to other people. And he gave very good reasons for those things. And
do you think the question with regard to any being in contact with any postings or newspaper articles covers Googling or searching for information online,
Not
being
really.
in contact with newspaper articles?
It touches on it, but it doesn't really cover it all. And I would also emphasize that the Googling part of this tip is a long way from the most serious allegation. I mean, the most serious allegation to me clearly is the pre-deciding, and it's the pre-deciding in a manner that is stated in the tip anyway, so aggressively that it is borderline as serious as the Lofton kind of going down to get the rope and at the hardware store type allegation. I mean, it's a dangerous statement that you've already found them guilty,
Very,
but it's
very
even
serious.
worse.
But let's go on to what the judge does next.
Yeah.
The judge makes findings of fact, and we know that we have to defer to those findings.
Right.
The juror is clearly puzzled why she's even up here answering questions. She seemed very sincere and very straightforward with her answers. She was about as candid and straightforward as she could be. And the judge basically makes a discretionary determination that asking more questions in, let's face it, a case where the defendants are charged with murder, witness tampering, conspiracy, weapons offenses, etc. The judge makes a sound discretionary determination. That's it. I'm not going to ask any more questions. I'm confident that she can be fair and impartial with her demeanor that he is assessing on the ground himself. This is an abuse of discretion standard.
It is.
So back to my original question. Besides seriousness of the allegations and credibility/reliability, are there any other factors that you think a trial judge should consider when evaluating the extent of the questions to ask a juror mid-trial?
No, because I think in the end, the question, and this was part of my original answer to Your Honor, is that capacity to affect impartiality is the concern. both of those things are involved in that. I think to some degree, it's going to be a sliding scale when you have an allegation as serious as a juror that has pre-decided the case in a manner so aggressive that she's going to burn the defendants, and that raises the capacity anyway of this to affect juror impartiality. Where I differ with Your Honor is in calling this a sound exercise of the judge's discretion. The judge barely touched on these allegations, and where the discretion lies, according to this court over and over and over again, and obviously these things come up in different ways in different cases, but the emphasis has always been on specificity of the questions in relation to the allegations. In other words, here, maybe start with, have you talked about the case at work? And then go from there. But there's just no specificity here about the most serious thing that's before the court. And to give Your Honor an idea of just how vague this was, remember how this arose on appeal. I happen to be the first of these three attorneys to handle this case in the appellate division. I'm reading the transcript. I see that an issue has come up with respect to juror number 8. I read this, I read the questions. I see the defense attorney is saying, Judge, you got to be more specific than this. I have no idea what's going on from this transcript. I read this transcript. I can't tell what the allegations are. That's how nonspecific these questions were.
Did anybody try to get more information after that while the case was still pending?
Not that I know.
Anybody try to contact any of these people or find out who the friend of Miss Worthy was? Or?
The only thing I would know is what's in the remand transcript.
Mm-hmm.
And remember also what's in the remand transcript. When the judge goes to address all of this in the remand, his summary of what this involved, these allegations, was, this was all about the juror talking and texting about the case. Now, it was about a lot more than that. But take the judge at his word for a second. His duty is to ask specific questions about the allegations. Did he ask any questions about texting or talking about the case? No.
Well, I mean, from a texting standpoint, I mean, the judge was probably trying to just apply common sense. We have a situation where if juror number 8 was planning to find these individuals guilty, the last thing juror number 8 is going to be doing is texting the defendant directly.
Well, yes,
the
and the texting, I'm sorry, I'm interrupting.
That's okay, go ahead.
The texting the defendant part of this is, remember, that comes out through the initial email from Rachel to the secretary. There's multiple layers of hearsay in there. So they try to sort it out by going straight to Stephanie. Now, when they go straight to Stephanie, is there any mention of that? No, it disappears. And Stephanie's the one who took the call. Now, I have a different view of that than the state does. My view of that has always been that texting defendant directly went away once you actually got to the person who took the call. State says, no, that's all part of the information that came in. Either way, first of all, did the judge, again, ask a question about texting? No. Second of all, as someone who has left a stray word out of an email or out of a brief, probably filed here at some point, maybe what it really said or was intended to say was texting about Ebenezer and his friends. I don't know. And the court doesn't know either, because no questions were asked about that, if you think that's important. Now, I don't think that was important, because by the time you get to Stephanie, that goes away. And now Stephanie's talking about Googling, sharing articles, and pre-deciding the case in this aggressive manner, referencing burning the defendants.
Counsel, can I ask?
Yes.
In terms of credibility, in terms of the authenticating this information, did anybody submit the transcript from the original jury selection process where juror number 8 was actually selected? Because I couldn't find it. And I'm wondering if not, do you happen to know whether at any point the Monmouth Medical Center was actually put on the record as part of the discussion with that juror?
I don't know the answer to that off the top.
That might be important in terms of whether or not that came through from the information in the telephone game, or whether that was something that was stated in open court.
I agree with you that that could be an important consideration. I don't know the answer to the question, though.
I thought that one of the trial defense attorneys looked at his notes and recognized that, oh, it must be number 8, not 15, as the original caller identified.
Right.
Because he wrote down the juror's name, what she did for a living, and where she worked in response to the biographical question during the jury selection process. But like Justice Noriega, I couldn't find that in the record, like the actual transcript of the jury selection process itself, and whether the model jury selection questions were identified and marked as an exhibit for juror number 8.
And just to follow up, whether she said nurse and hospital, or whether she said in particular the name of the hospital.
Yeah, I don't know the answer to that. And when the remand happened, I don't think they brought that transcript into the record at that point to talk about that particular issue. But in the end, this judge's job was to address allegations with specificity. And that's the problem here. I'm well aware of the abuse of discretion standard. If we were coming to the court and saying, this and this question and that question and that question and that question, they're all specific questions, but they could be tailored a little better. We could tweak those and make them a little better specific questions. That's not this.
But you were arguing, I thought earlier, to Justice Vitale, that the most concerning allegation was that the juror had prejudged the case. And it seems like that is the only question that was asked with specificity, because the judge said, and do you believe that you can listen to the evidence in this case? And as I have asked you, certainly throughout the voir dire process, listen to the evidence, apply the law as I give it to you at the end of the case, and render a fair and impartial verdict. And the juror says, I can. Presumably, if the juror had prejudged the case and was not planning on rendering a fair and impartial verdict, and instead was telling everyone, I've already decided that these people are guilty, then the answer to that would have had to have been
no,
something
I
else.
disagree with that. A juror who's walking around saying, I've pre-decided this because of my view of the evidence, may think that's a perfectly fair result. We don't know. There just weren't any questions asked going straight to this. We're bouncing around the perimeter of all this with very, very vague questions. Again, questions.
What specific questions should have been asked? Because the argument that the state raises on the other side is questions could themselves prejudice the jury, prejudice the answers that you're going to get, lead to some sort of partiality.
Absolutely have to be careful. There's no doubt. But I will point you to the case law. And there are so many cases that deal with this kind of issue, the appropriate questions on voir dire. They always emphasize the judge's discretion. I do not believe there is a single case in the state of New Jersey that says, Judge, you're being too specific. And look at Lofton. In Lofton, the judge was more specific than I would even suggest. In Lofton, the judge specifically talks to the juror about the fact that the juror appears to be favoring the defense. Now, with this rope at the hardware store comment, it could not be more specific. It may be exactly the kind of inquiry that the state's talking about when they're saying, "Oh, you can get too specific." I don't know, but again, this court had nothing to say about that. Now, I'm sorry.
Go back to your earlier answer, if you could. How many days or weeks did it take for the presentation of evidence, not the arguments, the presentation of evidence, and where does February 19, 2019 fall?
It's about the halfway point of the 40% point, somewhere in there, as I recall. And co-counsel can correct me if I'm wrong on that.
40% of
the testimony.
How many and how long did that altogether encompass?
It's weeks, Your Honor.
It seems as though the opening statements were on January 27th. I'm sorry, January 17th.
Right, and there are.
If you don't have it, we can come back to it on rebuttal or through one of your co-counsel.
Yeah, I have the trial beginning on the 17th and then concluding on the 17th of January and then concluding on the 27th, I'm sorry, on the 12th of March. So this happened about 40% of the way through the testimony, it seems like.
And with regard to the questions that the judge could have asked.
Yes.
Certainly, the judge has to be careful in asking these questions. But the judge here is faced with some allegations with regard to juror number 8's activities outside of the court. And in trying to determine, as we've already discussed, the information was communicated in a suboptimal manner. But in trying to determine the credibility of that, some of those statements and some of those allegations, would there have been any harm in the judge asking juror number 8 whether she had spoken to anyone about the case?
I was about to
Because
head there and then we got off on a, yeah.
going back to the jurors' instructions that were given at the beginning of the trial, that's usually instruction number 1. Do not talk to anyone about this case. Do not talk to even your fellow jurors about the case until the case is given to the jury for deliberation. So what harm, I know the state argues that there can be prejudice in asking too many questions, but that's a question that's tethered to the instructions that were given at the beginning of the trial. Do not speak to anyone about this case. What harm and what prejudice could have arose from just asking that simple question that at that point, depending on her answer, could have given more credibility to this tip that was received anonymously that may have not had all the indicia of incredibility as we see in some of the other cases.
I think there's no harm that could come from that. And I think that starting slow like that is probably the better way to go. I think another question that could start you slow is, what you work at Monmouth County Medical Center, what do they know about this trial? And I'm sure the first answer would be nothing. And then, well, they know something because you're here and you're obviously not playing hooky from work. So you told them something about this. What did you tell them? Oh, I told them I'm on jury duty. Well, have you discussed the case otherwise? Have you talked about what the case is about? And follow those questions down a line. And you may end up getting to a point of, have you expressed an opinion about the case? Now, I would personally, if I were a judge, I would not ask the questions that were quite as direct as the ones in Lofton, because the ones in Lofton cut straight to the chase. But again, they cut straight to the chase, and this court had nothing negative to say about that question. So that's where the vast discretion comes in. The vast discretion comes in terms of what specific questions you ask, but the duty to ask specific questions is what was lost here. And that's the problem. These questions are so vague. Again, I couldn't even tell what they were talking about. I had to file the first limited remand motion I have ever filed that functionally said, I don't know what's going on. Can someone tell me? And so they had this hearing. The judge then tells you, again, this all boiled down to talking and texting about the case. Well, you didn't ask about that either. And it didn't just boil down to talking and texting about the case. So did the judge ask about any of those other allegations? He barely touched on the Googling part. And that wasn't the most serious one. This is a potentially deadly serious allegation. A juror that has pre-decided the case with language so aggressive that, again, I will emphasize that it comes really close to the lynching type talk in Lofton. You've got to ask questions that head that way. How you head that way is all discretionary.
So I'm sorry, go ahead.
But the decision to go there is what's not discretionary. And that's the problem here. The judge didn't go there at all. I'm sorry, Your Honor.
If we agree with you that there was an abuse of discretion, automatic reversal, structural error?
I think so. The case law has been pretty clear that bringing jurors back, especially from this court, bringing jurors back this late is really, really disruptive of, the juror's life. And also, I think in this particular case, this questioning was so vague that is this juror even going to remember the facts that are critical to knowing this 6 years out of time? I mean, this trial was in 2019. I don't think you're going anywhere productive by doing that. So I would say, yeah, the answer is to reverse. And remember, this is a murder trial.
But a retrial you're talking about.
Yeah.
Not talking about, okay.
Yeah, reverse the convictions because the issue of juror impartiality was not properly handled by the court. And again, this is not us nitpicking about should have been this little change to a question or should have been that little change. This is a complete failure to be specific, which is what the case law requires.
Why not bring back the juror and ask questions of this single juror first? You said it's disruptive, but there's a lot of things that are disruptive.
I don't know that let's say this juror is somebody who talks a lot at work about just bring stuff up all the time. This juror potentially has talked about has offered opinions on many, many things in the ensuing 6 years. Is she even going to remember this conversation? I don't know. I mean, the burden
That's
at
true.
that.
Anytime you're asking somebody about a past event.
Well, yeah, but 6 years at a time.
You could probe all of that.
I'm sorry.
You could probe all of that. Have you spoken with others since? What have you talked about since? What's the downside to bringing back the juror?
Well, I think the case law generally frowns upon bringing back jurors after the fact in general. And then doing it 6 years at a time, I just don't think is going to be productive towards finding the truth. The one outlier in that is Bisaccia from the appellate division. But other than Bisaccia, the case law has been really clear. Failure to exercise discretion appropriately, which is the failure to craft specific questions. That's the problem here. That's reversible error. I don't think this court has ever said otherwise.
Counsel, you just answered Justice Pierre-Louis' question with when Justice Pierre-Louis asked about a question about talking to show the jurors. And you said there's zero chance that would have an impact. There's zero chance that would be problematic. But wouldn't you concede from the perspective of prejudice that every question you're asking that juror is potentially impactful? That every question you ask may lead that juror to think, what's this about? Why am I being asked this question? And we have a juror that says, that was found credible in saying that basically she had no involvement in whatever the judge was talking about. But who did ask, why are you asking these questions? So we have a juror, let me finish. We have a juror that was quite inquisitive about that. And every question that's being asked is going to have an impact upon the juror. And the length of that question is going to have an impact upon the jury, which is why it gives the judge a tremendous amount of discretion to say, let me look at the whole pot. Let me look at the allegation. Let me look at the credibility of it. You talked about dipping your toe into the water. No, actually, the phrase you used was bouncing around the perimeter with very vague questions. Maybe the judge wasn't bouncing around the perimeter, but maybe the judge was poking a little bit here and a little bit there to see what the receptiveness to that was vis-a-vis what other prejudice am I creating? And I have to admit, it feels to me like your perspective is just slightly dismissive of the notion of the impact this might have on a juror who might then be asking, why is he asking this of me? What do I have to be worried about? Are these defendants talking about me? Is someone talking about me? Am I being threatened? And that's why the judge is given this discretion on the spot to take into consideration all these different factors and try and boil them together. So I'm not sure this judge being careful is the same as bouncing around the perimeter. I think what this judge was doing was trying to make some initial inquiries to see where things might go so as to avoid the almost inevitable prejudice that would occur with more pointed inquiry.
Initial inquiries about what, though? The initial inquiries have to specifically go to the allegations. They don't have to go all the way, like in Lofton. It doesn't have to be 0 to 100 miles an hour in one shot. You can ask questions like, for instance, have you talked about this case at work? But the specificity requirement of the case law simply is not addressed by asking those things I asked you weeks ago. Anything change? Now, does the juror necessarily even remember that?
I'm not sure that's a fair characterization of what he did.
Well, that was the first question he asked. It was also, I think, the third question he asked.
And there were other questions. Can you still be fair and impartial? Have you been on social media? Have you been in contact with any newspapers or social media? I'm not entirely sure that's a fair characterization.
The only specific question that was asked, and it is a specificity that doesn't even address necessarily the Googling part of this, but was potentially to the Googling part. But again, the Googling part was not remotely the most serious of these allegations. Nothing that was asked touched upon the pre-deciding the case, because you may think if you're a person who's already made up your mind and you're going to burn them, you may think that's a fair result. So that fairness question is way too vague to get into this particular allegation. And this allegation is so serious that it requires more specificity than that. And again, the degree of specificity is up to the judge if you're actually addressing, if you're homing in on these particular allegations. But that's not what was happening here. Again, I respect the abuse of discretion as the governing standard here, but the discretion is to craft specific questions. When you don't do that, that's where the problem arises.
Other questions, anyone? Anything you'd like to add, Mr. Kirsch?
No, Your Honor.
Thank you.
Thank you.
Ms. McLean.
Thank you, Your Honors, and may it please the court. I also did not reserve 5 minutes for rebuttal, so I jump in with Justice
I
Oshali's.
won't ask you any questions immediately.
I was going to jump in by giving my answers to your factors to consider. So again, happy to answer any questions in any order. Your Honor had proposed 2 factors, essentially the seriousness of the allegation or its capacity to prejudice parties or the trial or the fairness of the trial, which is absolutely a factor. I think it is the primary factor on the front end. To Your Honor's questions about the reliability or credibility of the allegation, that is important. However, it becomes important on the back end. As this court's case law makes clear, the thing that triggers the duty to inquire is an allegation with the capacity to prejudice. And in this way, it's almost akin to, or an allegation like this is almost akin to something like a bomb threat. It's incredibly serious. If true, we need to do something about it. And so the mere fact that this allegation was made, we don't look at the credibility up front. The allegation has the capacity to prejudice, which triggers the trial court's obligation to ask specific probing questions about that allegation, about the specifically harmful parts of that allegation.
So the duty is to ask specific probing questions if there's a serious allegation of misconduct without regard to whether that allegation has any credibility whatsoever.
Essentially, yes. And I think that that is why it's the bomb threat analogy really works. Even if you are convinced that this is a hoax, that a teenager is telephoning and this is a hoax, everyone would be, wildly remiss in their duty if they're just like, oh, it's a hoax. I won't ask any questions. I won't really actually confirm it's a hoax. I just don't believe it. So let's move on.
Is the judge permitted? Oh, I'm sorry.
Go ahead.
Is the judge permitted to consider something other than a teenager calling and to consider the possibility that this was an effort to derail this trial that somehow had its origin perhaps in one or more of the defendants?
So first, there is no indication on this record, and the reason I think is because it's not that. But even if there were some suspicion of that, the judge has to investigate. That's what this court says in RD. That's what this court says in Tyler and in Bay. And for example, in Tyler, the juror says things about how she can't be fair, she can't be impartial, she wants off this jury. And the judge essentially makes a factual finding from talking to this juror that she is throwing a tantrum and she's trying to find the magic words.
I understand, but I don't know how you can dismiss the possibility that an anonymous call with the name of a person referred to, but we don't know anything about that person, which talks about a workplace discussion, when it may be that people outside of the core circle of attorneys and the judge on the trial knew about Juror 8's workplace. Can you really say there is 0% chance that this was an effort to derail the trial?
No, but the reason we can't say this is because the court failed in its duty to investigate. The court could have and should have asked Juror 8 specific questions. Have you talked about this case at work? Have you Googled the case? Have you formed an opinion about this case that you have shared with anyone?
So in United States versus Caldwell, which was that 11th Circuit case from 1985, which seemed like it had very similar allegations in that trial counsel received an anonymous call mid-trial reporting the name of a juror who had allegedly been discussing the case with her fiance as well as with another jury, and they agreed they were going to, quote, hang the defendant. And then the caller actually did call Chambers directly and spoke to the judge's secretary directly. And the 11th Circuit there just held that it was completely not credible and no investigation whatsoever was required.
That was part of the court's holding. However, in Caldwell, it's really instructive what the judge actually did in the face of that allegation. And first, the caller only called the court because defense counsel got this call and was like, you have to call the court. But what the court actually did was investigate. The court asked specific questions. The trial judge investigated, asked specific questions about the specific allegation, and based the finding that there's nothing here off of that investigation. And yes, the holding is, as Your Honor correctly states, but what the judge actually did is vastly different from what the court did here. And again,
Sorry, so what were all of the specific questions that were asked to the juror?
In that case, they don't list all the questions or I don't recall if they list all the questions. I can try to find it in my binder and answer on rebuttal.
No worries. It's just the part of the decision then that I saw was not the specific questions and was instead to require any investigation in the face of such unreliable accusations, which place an imposing burden on the district court to risk jury contamination from the investigative process itself when the court has no basis whatsoever to adjudge the reliability of the initial accusation. And that was just because the initial accusation was, as they called it, anonymous.
I absolutely agree that is the holding. That holding is not the law in New Jersey.
But it does seem, I recall from the opinion that it got to the point where at least the juror had admitted that she was talking to her fiance about the case. There must have been some inquiry.
Yes, the inquiry.
Talk to someone about this. I think that's the point you're trying to make. I think in the case, she gets to the point where she actually admits, yes, I've been talking to my fiance about the case. So at some point, someone must have asked her something about, did you talk to someone? Which
yes,
could be the most basic question.
Your Honor is more eloquent at the answer is me flipping through this binder here. But yes, that is essentially.
So you were saying that the duty to trigger is triggered when the allegation is serious, and the duty requires specific questioning of the allegations. It's a bright line rule that you think should exist without regard to any discretion whatsoever. That's it.
So the rule set forth by this court is if the allegation has the capacity to prejudice the court, that triggers the duty to investigate. What that investigation looks like is where the discretion comes in. But with respect to conducting that investigation, as this court said in Bay, the procedure of questioning an impaneled jury when prejudicial, in Bay it was prejudicial publicity, but when prejudicial publicity threatens the fairness and integrity of a defendant's trial, should not be invoked begrudgingly. This procedure is prophylactic in nature, designed to uncover potential prejudice to extremely significant constitutional rights that might otherwise go wholly undetected.
Different fact pattern completely, though.
Yes, but the underlying points remain the same. In Bay, we knew the court knew there were prejudicial news stories out there, but there was no evidence that these jurors had seen those news stories. And in fact, there was every reason to believe that the jurors had followed the court's instructions, which were surprisingly detailed of have your family members screen the newspaper for you and physically cut out any reference to this trial. And the judge gave those instructions repeatedly admonished the jury. And so the trial judge relied on those instructions and didn't ask the questions. And this court reversed the defendant's convictions in Bay because of the uncertainty, because of the court's failure to investigate that this prejudice might have affected. All of these cases are talking about possibilities, are talking about not the certainty that juror taint occurred, but the mere possibility, which triggers the obligation to carefully investigate. And that careful investigation did not occur in this case.
You mentioned that credibility would be important, but on the back end, how would it be important and how would the judge use that?
So once the judge actually asks the specific probing questions, then the trial judge can do what trial judges are best at and assess whether the person, having been asked these detailed specific questions, is in fact credible, is worthy of belief.
The credibility side of it is the juror believable, not is the allegation of misconduct credible. It's what you're talking about.
Yes, and the problem we have here seems to be this mismatch between What the judge seems to be doing is saying, well, I find this allegation implausible, not having asked any questions because you can't text an incarcerated defendant. I find this human being in front of me to be legitimately perplexed as to why she's been brought up to sidebar in a courtroom full of people, asked some very confusing questions. And when she says, what's going on? She's told essentially, go sit down, don't talk to anyone. And there's a mismatch between those things. What's missing is any real credibility assessment of this juror about these allegations. And that's the problem. And again, you can't make a credibility assessment about whether this juror has been Googling the case if you don't ask. You can't make a credibility assessment as to whether this juror has formed an opinion about the case that she has communicated to others if you don't ask.
Counsel, is it fair that it's your position, or do you agree with the position that the judge at the outset could have simply said, I don't believe this is credible. I'm not going to engage in it. I'm going to deny any requests to speak to this juror, and left it at that. But once engaged in believing there's some capacity for prejudice, they must do so with a certain amount of rigor.
Well, I absolutely agree that it should be done rigorously. I am a little bit hesitant to say that judges can just offhandedly discount with no investigation whatsoever plausible allegations. And again, I think the bomb threat analogy is helpful. You can't just say, I don't believe it, that's it.
You just said plausible allegations, whereas before I thought you said you only get to plausibility after you investigate. So I think the question here is there always a duty to investigate, or can some allegations just be labeled by the judge as not plausible and therefore not investigated?
So I would draw a distinction between credibility, which happens on the back end of is this juror telling the truth when we ask her questions, the specific questions you have to ask, and is this allegation plausible? So for example, the example from a co-counsel's brief about aliens, if someone calls the court and says, aliens are pushing juror 8 to vote a particular way, that is not facially plausible. The judge has no duty to investigate. If the allegation, there's no way that could be true. It has no capacity to prejudice. So whether you analyze it through either of those lenses, it can't be true. It has no effect. The judge doesn't have to start asking this juror, have aliens been telling you to vote a particular way? But if the allegation is plausible, it's almost akin to either the PCR context of are there issues of material fact that require a hearing, but assume this allegation is true. Don't make any credibility assessments up front, but take this allegation at face value. If true, does this require investigation? If true, is this a problem? And the answer in this case is absolutely yes. The Googling, the talking about the case at work, the predetermination of guilt are all significant problems. Even the texting would be a significant problem that ought to be investigated, that should have been investigated, and that it was the trial judge's duty as gatekeeper when corrective measures were possible if they were needed. And again, this is what's I going to say? I apologize. If the trial judge were going to say on its face, these allegations are implausible, at minimum, the judge should have contacted Stephanie. Perhaps OPD's phone systems captured Ms. Worthy's callback number. We don't know. No one ever asked. The judge never talked to Stephanie on the record to ask her, to the best of your recollection, what exact words did this person say? What information do you know about this caller? Anything like that. We don't know because all we have is this email chain. We don't know if Ms. Worthy mentioned the friend's name. It doesn't appear in the emails, but we don't know because the judge did not investigate. All we have are this email chain and the trial court's questions that do not ask, have you talked about the case at work? Have you Googled the case? Have you formed an opinion about the correct outcome and communicated that to everyone, to anyone?
We also have the judge's credibility findings.
I apologize, I didn't hear
We
you.
also have the judge's credibility findings.
Yes, but the judge,
Candid, sincere, straightforward. And I don't think in this context, you can ignore the fact that the judge did make a series of credibility findings.
no. However, first, this court's case law is clear that, for example, as to judges can't simply accept a juror's reassurance, oh, of course I can remain fair and impartial. This court's case law instead says it's the judge that has to make that determination after asking these specific questions. And as to the questions the judge did ask this juror, we accept that the judge found her answers to these questions to be credible. She wasn't lying when she answered that she believed she could be fair and impartial, but that's not actually what's the heart of this allegation. The question is, in light of this allegation, has the juror predetermined guilt? Has she spoken about the case to other people? Has she shared opinions about the case? Has she predetermined guilt? That wasn't asked.
Isn't prejudgment antithetical to impartiality? No, I don't, by asking, are you impartial? Can you be impartial? Are you saying that also may imply that she has already prejudged the case?
I think that, well, two parts of that. First, I think that the way in which this voir dire was conducted was unlikely to lead to the most open and honest answers from the juror, because remember, this is a full courtroom on day 12 of a murder trial. The jury is in the juror box. This juror is up at sidebar being asked questions as everyone is staring at her. I think that would make anyone nervous. And so I think that's the way it was conducted is a problem. I also think that the best practice should be to do this in an empty courtroom with the parties, the judge, and the juror present. I also think it's important to emphasize upfront to the juror, essentially, you're not in trouble. The most important thing to be is honest here, no matter what you say.
It's discretionary with the judge, because the judge, having the proceedings stop, the jury dismissed, except you stay here, and a courtroom in which one person is the focus may in fact be more problematic in terms of the impact on the juror. I mean, shouldn't we leave those types of procedural details to the trial judge?
Yes, the trial judge has discretion, can manage their courtroom how they see fit. However, this voir dire was extremely abbreviated, potentially.
No, I understand your point, but you're saying that we should be imposing on judges best practices as to whether to bring the juror to sidebar, leave everything else in place, presumably out of the earshot of the other jurors, or clear the courtroom.
I mean, from how across many transcripts I have read, even minor things like scheduling, or I've got my kid has an appointment tomorrow, I'm going to be late. These usually are not done in open court with everyone staring. It's not unusual to have a juror speak privately in a courtroom with the parties and the judge. I'm not saying it's absolutely required, but because of the importance of conducting a thorough inquiry that's really designed to get at the truth, I do think that guidance from this court about things that could further this truth-seeking function of the voir dire are important to emphasize.
On behalf of your client, Mr. Spraulding, what's your position on whether recalling this juror at the stage for fact-finding is appropriate?
Absolutely not, for 3 reasons. First, that is not what happened in Bay, Tyler, or Lofton. In Bay and Tyler and Lofton, again, we were left with this uncertainty as to whether any juror taint actually occurred. In Bay, we didn't know whether the jurors had seen these prejudicial news stories. In Tyler, there was the court did not know whether the juror who'd been, sitting there as a punishment had communicated with the other jurors, though she'd been told don't do that. And in Lofton, similarly, the one juror was dismissed, but
I'm not saying it. I'm talking about now. What do we do now?
So again,
2025.
Reverse convictions and remand for a retrial.
And you're opposed to any inquiry to the juror at this stage.
I will take that over affirming this conviction. However, Tyler, Lofton indicate that reversal is the correct remedy.
Is there any other reason aside from the cases that you've cited that you would point to as a basis for us not calling it for?
A remand is too little, too late. It's, again, this trial was in February 2019.
Did not do any kind of remand.
No, the correct answer is to reverse because the trial judge failed in the gatekeeping duty to ensure the impartiality of this jury, and that absence of a record, the absence of an inquiry, demands remand. In the analogous context in Azario, where the issue was a Batson-Gilmore challenge, this court reversed those convictions essentially because it was too little, too late. At that point, the same holds true here.
Is this really analogous to Batson-Gilmore?
The problem in Azario was that you were essentially trying to reconstruct what someone was thinking and doing 6 years earlier. And that's exactly what this remand, if there were a remand, would be.
You're opposing. Okay.
It is a backup position. The correct answer is, my opinion is that this court's case law makes clear that the absence of a record is error in and of itself.
Let me ask it more precisely then. Do you object to a remand?
You've given us your view. You're against.
We got it.
You're against
we
remand.
understand.
Okay.
Yes, go ahead, we'll take it, yeah.
Is there anything else you'd like to add?
Again, this is a disturbing allegation, and the trial court did not investigate it properly. And that is an abuse of discretion that requires reversal of Mr. Spraulding's convictions.
Thank you, Ms.
Could I I'm sorry, just real quick. In terms of the transcript from jury selection, do you happen to know if that transcript reveals the information that juror 8 delivered?
I honestly do not recall. One of the other reasons for remand is the appeal itself took close to 5 years. And so I honestly do not recall. I see in my transcript here, there are some jury selection transcripts. I do not recall if they reference juror 8.
Thank you.
Thank you. Mr. Burns.
I always reserve 5 minutes, so I will continue on that. And I also reserve 2 minutes rebuttal time only if necessary. May it please the court. The question today is what inquiries are required when evidence shows potential juror bias, notwithstanding this court's instruction that an inquiry into possible juror trial, juror taint should include, quote, searching questions, unquote, into the specific allegations. The appellate division held that if a trial judge believed that the allegations were not credible, a less extensive inquiry was sufficient. Here, specific allegations of juror bias was made. A Miss Worthy, allegedly friends with a co-worker of juror 8, who worked at the Monmouth County Hospital, called Stephanie at OPD, claiming the juror had predetermined defendant's guilt. Stephanie relayed this information to Rachel, counsel's secretary, who in turn contacted the trial court secretary, further alleging juror 8 had been texting co-defendant Byrd. The trial court's clerk spoke directly to Stephanie to, quote, get more detailed information.
Mr. Burns, trust us, I think we've covered the facts. Why don't you jump into your argument?
Then I'll go to the credibility issue, because I do want to argue that. We've already said what questions were not asked. I won't repeat those. And we also know that over co-defendant's objection, juror 8 was questioned in full view of the remaining jurors at sidebar, thereby singling out juror 8. Now, the trial court found that, quote, juror 8 was clear and unequivocal. My argument is that finding is only as good as the questions that have been asked by the trial court. Because the trial court asked no probing questions of juror 8, its credibility findings have limited value. Relying on Rachel's triple hearsay email, The trial court concluded the allegation of juror 8 had been texting Byrd had been fabricated because Byrd was then in county jail without access to a cell phone, and therefore found the remaining allegations not credible. This selective reading of the record, though, ignored the court clerk's conversation with Stephanie at the OPD. Best evidence was that Stephanie told the clerk and not what Rachel earlier had told to the judge's secretary when the issue of text messaging first surfaced. Remember, the trial court finds incredibility because of the texting allegation, but the texting allegation only comes from Rachel Blaché in her email to Melissa, the court secretary. When Cynthia, the court clerk, goes to talk to Stephanie directly, no allegation of text messaging was made. So the whole basis of the trial court's credibility finding was based on a selective reading of the record. The trial court ignored his own court clerk's findings discussion with Stephanie. We should not give those type of credibility findings deference. Selective reading of the record, to me, is arbitrary and capricious. Flagg versus Essex County Prosecutor Office, where this court said an abuse of discretion should not be deferred to if it's based on a selective or improper reading of the record. It becomes arbitrary and capricious. And that's what happened here. The judge didn't believe the allegations. He thought they were fabricated. Possible witness tampering was going on here. So be it. But he selectively read the record to find that the allegations were not credible. So this entire transcript on 16T is about a page and a half of questions of juror 8. No specificity about Google. No specificity. Do you happen to know Miss Worthy? No specificity. Did you talk about the case to your coworkers? Nothing at all. Did you use the alleged language? Now, we spoke earlier that we don't want the juror prejudiced by those 2 probing questions. It will stand a juror surrounded by 5 attorneys, observed by all the other jurors, and put that juror on the spot? How is that not prejudicial? How does that not infect the trial?
Is there any law? I'm sorry. You're continuing.
Sure. Then the trial court erred by, which has not really been mentioned, when it failed to conduct a voir dire of other jurors. We still don't know whether juror 8 spoke to other members of the jury panel about the case because nobody asked. We still do not know if she discussed the case with the other members of the panel. He could have asked. The trial judge could have asked. He didn't. As the allegations were specific and there was a realistic possibility of juror taint, and that's the standard, a realistic possibility. We have specificity here. We have a name. This was not an anonymous call. It's a named individual, someone named Worthy. Look in the telephone directory, find the name Worthy. Go to the public defender, ask them for caller ID. Stephanie could have said when the call came in, the data came in. He could have asked the sheriff's office to investigate this. He could have asked the state to investigate this. He could have contacted the public defender's office to get that very specific information. Anyone who's ever used the PBX system of the public defenders knows that caller ID comes through. It's common knowledge.
In this case, the public defender's office was involved in the trial, correct?
The trial attorneys were appointed, yes, designated counsel.
So at any point, did they offer any of this information that you say was within the knowledge of the public defender's office?
What they did is ask the judge to investigate it.
I didn't see any specific request that said, here we have Ms. Worthy's phone number. You should contact her directly, or Stephanie can find out more information about Ms. Worthy's phone number. Someone should contact her directly, or anything like that.
They didn't ask those specific questions, but they did ask the judge to undertake a probing inquiry and investigation into the allegations. That was asked several times by Byrd's co-counsel. He made that very clear at the remand, and that wasn't done. Remember, these investigative tools were available to the court. They're there. You have a sheriff's department. You have the state itself with its massive investigatory powers. You could have contacted the public defender. You didn't. None of this was done. The judge didn't believe the allegations. We know that. He says that. Well, the reason he didn't believe it was an incorrect one. He didn't believe it because he said texting messages in a jail cell is not possible because inmates don't have cell phones.
Said a little bit more than that, though.
That's really what he said.
Well, let me quote what he said then.
Go ahead.
So clearly, as I indicated, my recollection was that there had been some outside Googling and that there was an allegation that there was a predetermination by one of the jurors. I did not want to taint the rest of the jury with regards to something that may have certainly been all fabricated. So as to the question of fabrication, he specifically addressed Googling and, as counsel said, the most important serious allegation here of predetermination. He did not say that this whole thing was fabricated because the defendant was in prison and didn't have a cell phone.
Actually, I would respectfully disagree because the appellate division itself goes at length and it's put
I'm
its own
quoting it
opinion.
right from the record, not from the appellate division
I
decision.
read in the, well, I will be happy to look and cite to the record. It's probably in my brief, but the appellate division itself goes at length about the texting. They cite to the judge saying this is why the judge found it was fabricated. That's the appellate division's
I'm
decision.
going right to the
I believe
words
that
from
the-
the judge. That's what I'm basing what I'm saying on.
Well, I will look in the transcript and come back to you on that. My argument is that the appellate division announced what I would call a modified rule that weakened this court's clear jurisprudence on an issue that directly goes to an individual's right to a fair trial. Unlike this court's instruction that alleged juror bias requires a search inquiry and a voir dire of remaining jurors to ensure that the taint is not spread, the appellate division now says if the trial judge doesn't believe the allegation, a limited inquiry is sufficient. Now, the trial judge stands as the gatekeeper. He stands before the state and the defendant's liberty. He's a neutral magistrate. He stands there as a gatekeeper of our constitutional rights. This is a Sixth Amendment right to an unbiased jury and a fair trial. Now, I want to read a quote here, and the court can decide if this is what was done. This is RD at 560-61. This is what this court said. An appropriate voir dire of a juror allegedly in possession of extraneous information mid-trial should inquire into the specific nature of the extraneous information and whether the juror intentionally or inadvertently has imparted any of the information to other jurors. But no stretch of the imagination was this done here. This is a performative, this is pro forma inquiry. I counted 3, maybe 4 questions that were relevant here. And the entire transcript in 16T is about 1.5 pages. And none of the emails, by the way, were shared with defense counsel. That came out at the remand hearing. So none of these chain of emails have been shared on February 19th, 2019, when juror 8 was questioned. And in fact, I believe one of the counsels at the remand hearing complained about this. This should have been made available to us, and it wasn't. So how can we say that the judge's discretion did not abuse its discretion when he already made up his mind? And I would still argue that he relied heavily on the text messaging. Certainly the appellate division thought so. And how was this a search inquiry? How was Jean-Baptiste and the other defendants' Sixth Amendment right protected? The judge has an obligation not to compromise the juror. I understand that, not to put the juror on the spot. He also has an obligation to ensure that the defendant's Sixth Amendment rights are protected. And that not happening here. In answer to the question on what should be done here, there's only one solution. The conviction has to be reversed, a new trial. And why is that? Because this was a fairly notorious case. The facts are very troubling. We have no idea since the remand hearing, since the Supreme Court granted petition, how much of this information is now in the community.
And do you oppose, as your colleagues do, any attempt to reconstruct or supplement the record of the state?
I do. I think that the issue here is so profound of the Sixth Amendment, the only remedy is a reversal. To do otherwise, I think, would significantly weaken this court's past jurisprudence.
Thank you.
Thank you, Mr.
Thank you.
Bruce. Ms. Harrigan.
Your honors, and may it please the court. This court in State versus RD gave specific guidance to trial courts to address mid-trial allegations of juror irregularities. The first step is for the trial court to determine if there is in fact taint. To make this determination, a trial court is to question the juror in the presence of counsel. That happened in this case. If and only if a court determines that a juror has been tainted, Is the trial court required to go further and expand that inquiry of the juror to determine if any of the other jurors have been tainted? Having determined that juror number 8 was not tainted, there was no need for Judge Oxley to continue or expand his inquiry. Nor was there any real credible indication from the allegation itself or from juror number 8's response to Judge Oxley's questioning to indicate that Judge Oxley needed to go further. Yet despite the clear guidance that this court gave in RD and Judge Oxley's adherence thereto, the defendants in this case asked this court to change the law in RD and collapse the two-part test. In doing so, they asked this court to essentially jettison the first inquiry, the trial judge's determination of taint, in favor of a per se rule where any allegation of juror misconduct is automatically deemed credible and prejudicial. However, the process that this court outlined in RD works. More specifically, the process outlined in RD worked in this case, and the law does not need to be changed because a per se rule is not necessary based on the facts and circumstances of this case. The manner and extent that Judge Oxley questioned juror number 8 was, as specifically described in RD, a proper exercise of discretion. When faced with mid-trial allegations of juror misconduct, proper judicial discretion necessarily includes a judge's determination on how to investigate the claim. Experienced trial judges like Judge Oxley know that judicial discretion is the exercise of sound discretion guided by law. Here, Judge Oxley was faced with an essentially anonymous tip that was facially inconsistent and dubious at best. It alleged 4 separate types of misconduct. And because part of the tip named defendant Byrd, as texting with this juror, Judge Oxley had to exercise caution as to not inadvertently interject prejudice and taint. His carefully crafted, broader approach to start with general questions, which in the face of the juror's denial, did not lend an opportunity or the need for a more expanded inquiry. This initial inquiry revealed no admissions and no taint. Juror number 8 wholly denied she received any outside information in any form. Juror number 8 never expressed that she had personal knowledge of facts not in evidence when specifically asked about newspapers and postings. More importantly, she never confirmed that she engaged in any improprieties like we see in all of the other cases on this issue. She also confirmed that she could listen to the evidence in the case, that she could apply the law as the judge instructed, and that she could render a fair and impartial verdict. The defendants here covertly focused their arguments not on the totality of the allegation that Judge Oxley was faced with, but only in the part of the allegation that favors their clients. Because to admit that part of the tip suggested that juror number 8 had some type of relationship with Byrd through text and his friends, that's through texting, is to admit that the tip is internally inconsistent and with their primary argument that this juror had predetermined the case. In other words, defendants asked this court to deviate from the longstanding principle of analyzing the totality of circumstances and ignore, as the appellate division pointed out, the 2 seemingly conflicting claims of misconduct. As the appellate division held, and as this record reflects, Judge Oxley relied on his own objective evaluation of the juror's credibility based on her answers to his questions and her demeanor, which he specifically described as straightforward, sincere, yet puzzled as to why she was even up there being questioned. And Judge Oxley's real-time decisions and these credibility findings should weigh heavily here. This case exemplifies why the first step in RD is so important. Judge Oxley properly weighed all of the relevant factors and applied the proper balance between them in determining that juror 8 was not tainted. The totality of the circumstances is a standard that is replete and relied upon in our law. It is a standard that in this case showed the care that Judge Oxley took in this situation. In sum, the process in RD works.
You're done with your opening statement?
I am.
So there's a serious allegation, of course,
Yes,
that a juror predetermined the outcome of the case while the evidence was still being presented.
that's part of it,
And
yes.
the judge asked, and that's the one I want you to focus
Okay.
on with me. The judge asked a number of questions. Which of the questions specifically addressed that allegation?
The allegation of whether she had predetermined the
The
case.
juror had predetermined the case.
He asked, he asked, I think, if she had predetermined the case, if she had any outside information. He specifically asked if she had any outside information or if she,
But that doesn't go to whether she predetermined the case.
He
I want you to focus on that allegation
okay,
and point us to the question? And if that's your answer, that's fine.
Nope. He specifically said, do you believe you can listen to the evidence in this case? And as I have asked you certainly throughout this voir dire process, listen to the evidence, apply the laws I give it to you at the end of this case, and render a fair and impartial verdict.
So the judge there asked, can you hear the evidence and ... and be fair?
Correct.
Is it unreasonable for a juror to hear that and say, I've been listening to the evidence, I've been listening to it impartially, I've been listening to it fairly, and I think this person is guilty? How does that question negate the allegation of predetermination?
I believe the specificity of can you render an impartial verdict? He specifically talked about the actual verdict. Can you render an impartial verdict?
I'm a juror and I hear that and I think, sure, I can render a fair verdict. And my verdict, even though I haven't finished hearing all the evidence, is guilty because of what I've heard. And I listened to it fairly, I listened to it impartially, I didn't talk to anybody, whatever. How does that specifically negate the question of predetermination?
I think all of his questions put together, Your Honor, if you look at all of his questions and what he asked in the totality of it, I mean, they were broad questions. They were meant to be broad questions. And I believe if what Your Honor said, if this juror had any indication or any concern about what Judge Oxley was asking her, she would have said, I don't know what you mean. I've been listening to the evidence.
So what other questions would you rely on in particular that go to the question of predetermining the outcome of the case?
I believe it's significant that Judge Oxley asked her if she had received any outside information, because that would make sure that anything, because she's allowed to have an opinion, I mean, not discuss it obviously until jury deliberations with anyone, but when a juror listens to testimony, they maybe form opinions. They get back in the jury room and they discuss those opinions that they've come to based on what they heard. I think it's, I think this particular juror number 8 was confused. I think if she didn't understand, if she says, well, if what you're saying is true, I have been listening to it, and she would have said something.
I had understood that you were also focused on the original question about, you remember what I asked you about on voir dire, has anything happened that would change that? Is that something that you rely on as well?
The original voir dire question, certainly. I mean.
So then tell us, if you can,
sure,
what specific question from the voir dire covered the question of predetermining the outcome?
Predetermination.
Was there any instruction during voir dire that you have to listen to all of the evidence, you can't predetermine, you can't come to conclusions in the middle of the case, you have to wait and not decide the case until the end?
Yeah, Judge Oxley, that sort of instruction was given right after the jury was sworn. It was given, before every break. And Judge Oxley was specific. He said, please do not discuss this case with anyone. If you start talking about the case, that person will say something that might affect your thinking about the facts of this case.
I think that's all important, but those are instructions that the court is giving. And what happened at this voir dire was the judge said, series of questions we asked you. So there is a distinction that a juror could draw between the questions posed at voir dire and the instructions that were given, which were not asked about. Which question during voir dire went to predetermination?
He specifically, I think the first question he asked was, is there anything that's happened throughout this trial that would affect your answers to those questions, meaning voir dire?
No.
Okay.
I understand that. But which question at voir dire?
Oh, okay.
Pivoting off of.
For that particular, or for the impartiality?
The question you just read.
Oh,
as relates to predetermination.
Okay, so that particular question, anything happened throughout the trial that would affect your answers to those questions? The voir dire questions that specifically relate to that is, do you know the defendant? Have you heard about the case from anything other than what I have told you or the judge has told you? Would your verdict be influenced by any factors other than the evidence in the courtroom, such as friendships or family relationships? And again, the allegation itself said she was talking with Byrd and his friends. Is there anything about this case that would interfere with your ability to be fair and impartial? And again, I think that goes directly to outside information. I think it goes to if she knew, again, the defendant, if she knew any outside information from this case.
So how do questions like that are asked at the outset cover a situation after the trial has already gone with 30 days of evidence?
Your Honor, I think you tie in the specific question that Judge Oxley asked with the fact that, you know, the voir dire questions, do you know that? Because a juror is going to remember questions like, do you know the defendant? You know, have you heard anything about this case? Have you been to the scene?
There are a lot of questions asked during voir dire.
There is.
A lot of questions.
There is.
And jury selection took place over a month prior to February 19th, correct?
Yes.
And during the course of that time, that juror has listened to a lot of information, correct?
Yes.
So I'm not sure we can assume a juror standing there being asked, out of the dozens of questions you were asked at voir dire, everything's the same, and remembering and recalling specifically all of those questions.
Again,
that's a difficult assumption to make.
I would answer that question with the assumption that if the juror didn't understand what questions Judge Oxley was talking about, or she had any sort of indication that she was confused about that, she would have said, what questions are you talking about?
So the burden is not on the judge to ask specific questions. So the burden is not on the trial court to ask specific questions. It's to rely on the juror to respond with inquiries about the questions that are being asked?
I think it depends on the circumstances of the case, Your Honor. I mean, again, we are dealing with a situation here where this was an anonymous tip because we don't, as Judge Oxley put on the record, we don't know. And as the emails say, is Miss Wordy, W-U-R-T-Y. And the transcript, you know, the transcribers and listening, they termed it Miss Worthy. So we don't even know that her name is Miss Worthy. And Judge Oxley specifically said, we may never know who Miss Worthy is.
An anonymous tip that provided specific information with her full name and where she worked,
which is something that could have been done in open court when they did the voir dire.
You say could have been. I know we've talked about the fact that none of us have the transcript from the jury selection. In open court, all the jurors say their full names.
When they're called up, yeah.
They're called up, and then they say exactly where they work and their
I believe the general questions are, you know, where do you work? Where do you get your, you know, where do you get your news from? It's, you know, once you're in the box, you know, they ask those general questions once you're already in the box. That happens in my experience.
I want to come back to some of the questions that you identified from voir dire. And my question to you is, how do they bear on predetermination month later? The first one you pointed out was, do you know the defendant? What, if anything, does that tell us about whether something is predetermined after multiple weeks of evidence? I don't know how that question helps.
Well, I mean, again, I think if you're looking at the questions in their totality, all of the questions.
I want you to tell us specifically which questions we're hearkening back to from voir dire, because that's one of the areas that we're relying upon to say there's been no predetermination here. So what are the building blocks? That's what I was asking. And the first one you identified was, do you know the defendant?
Yes.
What does that tell us about whether a juror 30 days later has predetermined the outcome of the case?
Well, I think that if she knew the defendant, I mean, again, he's trying to do a broad question by not interjecting taint to find out that first part of the allegation if she's texting with Byrd. Because if she was to ask directly, were you texting with the defendant, then you're necessarily going to taint her. You could possibly interject fear in her. You know, why am I being singled out? You know, that you've got 3 people on trial for murder. I think there's a real possibility of fear here. I think Judge Oxley, in using the voir dire questions, was making a real-time decision in the best way to determine if she knew defendant Byrd without asking, do you know defendant Byrd? Because one of the particular questions in voir dire is, do you know the defendant? Have you been to the scene? Do you know any of the witnesses? Would anything affect, would your verdict be influenced by factors other than the evidence in the courtroom, such as friendships? And so I think that was his way of answering that particular allegation. And she emphatically said no. She didn't ask, I don't understand. She didn't say, I don't know what voir dire questions you're talking about. She emphatically said no. And once she said no, there was no basis. I mean, the broad questions were meant to sort of funnel in. You know,
Can we get a transcript of her voir dire?
I guess we can. I didn't file the appeal, so I just have what was given to me on e-courts, but I'm sure we can.
Right.
I'm sure we
Don't
can.
do anything until you hear from the clerk of the court.
Okay.
just to follow up, you mentioned that she would have said her name, her full name, and where she worked. But in the biographical questions of the voir dire, it specifically says, please tell us the type of work you do and whether you have ever done any type of work which is substantially different from what you do now. Specifically, what's left out of that is the precise location, because jurors are not really asked either their address or precisely where they do their work, because saying Monmouth Medical Center is very descriptive in terms of knowing precisely where they work, as opposed to I work down at the Federal Plaza or whatever.
I believe the Monmouth Medical, Judge Oxley specifically asked her where she worked.
How do we know that? How do we know that? Because the
Oh, no,
attorneys
when you brought her up.
in the reconstruct, right? But I'm saying, how
Are
could
you
it
mean
have
in the
been?
middle of the trial? We're talking about during voir dire.
We're talking about the fact that
Oh.
some anonymous person has said Monmouth Medical Center.
Mhm.
If that person had that information and juror number 8 happened to work there, but that's never come up during the entire course of the trial, that's a particularly important piece of information to connect those two details.
Mhm.
So that's what I'm trying to figure out, because it shouldn't have come up in voir dire under the biographical section. It should not have.
And again, Monmouth Medical, I mean, again, we found out during the during voir dire of juror number 8 that she worked at Monmouth Medical.
No, and I'm sorry to interrupt you, but what we found out was that the attorney looking at the notes said,
Yes,
well,
that's
she
correct.
said
I was just going to say.
she said she was a nurse,
Mhm.
which means they're corroborating the fact that she does work there because she's a nurse. But it doesn't specifically say, oh, she said she worked at Monmouth Medical Center.
Your Honor, the record,
You
we don't
referred to
have the voir dire,
question,
so
"Ma'am, where do you work?" And then she said at Monmouth Medical.
That's
But that's of course after the tip has
That-
already been received,
That
right?
is correct. And unfortunately, we don't know because we don't have the record. If she was asked where she works when she was originally voir dired, I do know that the argument below was that from the prosecutor was that this was information that was given during voir dire. So that's what the prosecutor said on the record, that this was information that was given on voir dire. And I believe it's something that Judge Oxley mentioned also, and in the recreation of the record.
Defendants argue that this was not an anonymous call because the person gave her name and because OPD had her phone number through their phone system and simply no one at the court ever asked. So why do you call this an anonymous call?
Your Honor, I don't know that we know for a fact that Miss Worthy or Miss Wordy, that anybody had her phone number. There's nothing in this record to suggest that the public defender's office had her phone number or that they called her back.
Correct, but that has nothing to do with whether it's anonymous, right?
I'm sorry?
Is that specifically related to whether it was anonymous? It seemed like your argument was this was an anonymous tip and therefore there wasn't really any kind of investigation that had to be done beyond this very generic questions because it wasn't credible, it was anonymous. But why do we think it was anonymous if the person gave her name?
Well, I think if we look at the emails, and I submitted into the court their PA2 and PA3, I think when you, when you look specifically at the emails, the first part of the call that came in essentially said that she didn't want to give her name and that she didn't want to, she knows the juror's name but did not disclose it and that she would call back. They received a call on an unidentified woman who then said she had information on one of the jurors. And then when the court clerk called Stephanie at the public defender's office back, she got more information. And that's when she said the woman identified herself as Miss Wordy ? She said that she doesn't want to be involved any further. And she claims she has a friend who works at Monmouth Medical Center. And she said, I believe juror number 15. I don't know if that means that Stephanie thought it was juror number 15 or that juror number 15 was the one that the caller. It's not clear from the email, but I think either way, it's unclear as to who exactly the caller was talking about as far as the juror number. She says she's been Googling the case, showing articles and talking about it with other people, and that she's already predetermined the case. And so, the fact, again, we're looking at what Judge Oxley was faced with when he got this tip. And essentially, you get this first part that comes in that says she wouldn't give her name. And then all of a sudden, you get this information that's Miss Wordy, and you still don't know who she is. And as Judge Oxley put on the record, we may never know who she is. She didn't say how she knew the friend. And again, we're talking about Monmouth Medical. It's a fairly large hospital in Monmouth County with probably thousands of employees. And so it's a friend. The tip didn't even say that it was a coworker of the juror. It just said a coworker. Let's see. Let me make sure I'm saying this right. She says she has a friend who works at Monmouth Medical with juror number 8. And so we don't even, I mean, so there's really no way to sort of follow up on this. There's no way, I mean, who are you going to call at Monmouth Medical? It's a friend that works. You've got thousands of employees. There's no way to even, no way for the judge to even find the friend that maybe heard that this juror was talking this way.
But in
Call
theory,
Miss Worthy, and ask her, who'd you talk to?
I don't know. We don't have a phone number as far as I can tell.
but if she originally called and didn't give her name, and
Mhm.
then we find out that her name is Ms. Worthy, then it seems like someone must have spoken to her again, because
I think she
where
called
did the
back.
name come from?
Yeah, it says she would call back, and then we get more information, and now we have her name. Well, the other thing that I think is interesting, Your Honors, that I think needs to be taken into consideration is, you know, this call came in on February 19th. This was, I believe, 2 days prior, the jury had just heard the testimony on the witness tampering. And so I think the timing of, again, this is all of everything that Judge Oxley knew at the time and what.
I'm sorry, I missed that. It was 2 days prior to
Yeah.
what?
It was actually on the day.
On the day of, I'm sorry.
On the day that Narika Scott testified. She got done testifying on 2/19. Narika Scott was one of the witnesses for the witness tampering. Elizabeth Pinto, she was another one of, and she was right before, and that was on January 30th and the 31st. And so the jury had just heard about witness tampering, and all of a sudden, right before lunch, when Ms. Scott was done testifying, we've got this allegation that one of the jurors, 4 separate allegations of what this juror is doing. And so again, this is all of what Judge Oxley faced, what was in the tip, the inconsistencies in the tip, because the first part of the tip said she was texting with Byrd and her friends, and then the second part of the tip said she was going to burn them. So, but that's just inconsistent
The
because
first part of the tip was not recalling the direct conversation with Miss Worthy, correct?
I think
That was from Stephanie to the secretary.
no, it was
Once the phone call, once someone spoke to her
Yeah,
directly,
it
that's
was-
when the information.
Well, it's interesting also that Rachel is Byrd's attorney's secretary. And again, we have a situation here. There's another thing. We have a situation here where you've got 2 of the defense attorneys who are appointed by the public defender. When they get up and they stand up and they say, my name is Mr. Smith and I represent so-and-so, they don't say I'm from the public defender's office during trial. And so how did this caller know that Byrd was represented by the public defender's office in order to call the public defender's office? There would be no way of that person knowing.
Was there any attorney on the case that was an assistant deputy public defender, or were they all assigned counsel?
They were signed. They were designated counsel.
So there was actually nobody on the case that was actually from the public defender's office at the time.
That is correct. They're both designated counsel and one was private.
Is there any harm, was there any harm to asking juror number 8, have you talked to anyone where you work about this case?
I don't think there would be any harm in that, Your Honor. However, again, I think the real-time decisions that Judge Oxley had to make based on what the allegation was, he was trying his best to not get too specific and to ask the broad questions that would then lead to the narrowing. And so by asking, do you have any outside information? I believe that covers that, Your Honor. I believe Judge Oxley believed that.
Did you talk to anyone at work about this case? Could be her sharing information about the case with someone at work. That is not covered by, do you have any outside information? That would only be covered by, have you said anything about the case to anyone?
I still believe that's outside. I still believe that would be covered by outside information, Your Honor, because we have boundaries, and again, these are instructions that this juror had heard over and over again about. You can only consider the evidence that is in this case, and so
My question was, and in terms of any posting or newspaper articles, is there anything outside of what's been in this courtroom that you have been in contact with? How would that cover? Have you yourself stated anything about this trial to anyone else?
I believe being in contact with other people, I believe that covers that. I believe outside information in contact with other people covers that. Again, knowing that Judge Oxley was being very careful and seeing if she could, because let's just hypothetically say she said yes. If she had said, I mean, we have to understand here that this juror denied everything. Unlike the cases, this case is sort of unique. All of the cases that we have on this particular issue, we have instances where the juror admitted to doing something.
With more direct questions, though.
Right.
But also, we also had instances where other jurors had told on them, or again, we had credibility. We have a credibility problem with this particular thing. In the other cases, there wasn't a credibility issue, and so
Credibility issue with the allegation. Now, defense counsel argues that the judge predetermined that the allegation was not credible based pretty much on the texting with Byrd portion of the tip that came in on the front end and then disappeared later when there was a more fulsome conversation with Miss Worthy. Now, in making his determinations on the record, he indicates that he believes the juror number 8 was candid and straightforward and puzzled, but then says, I understand it originally started out that this juror was texting with Ebenezer Byrd and her friends and his friends, and clearly that couldn't happen because Mr. Byrd has been in custody for quite some time at this point without access to computers or texting or Facebook or any of those other things. So I'm satisfied at this point that we can proceed. Is your next witness here?
Mm-hmm.
So defense counsel's argument is, in that moment, the judge made a determination based solely on the texting part of the allegation. And it kind of sounds like from the transcript, that was the determination. What is your response to that argument, given what was said in the transcript?
I would disagree, Your Honor. That was a credibility determination that was made after he questioned the juror. He didn't make that determination before he texted
I understand that.
I mean,
but there were more parts of the allegations than just texting with Ebenezer Byrd. Would you agree?
That is correct.
But after questioning juror number 8, after making the determination that she was puzzled, that she was candid, straightforward, a couple sentences later, he begins by saying, I understand that this originally started that she said this juror was texting with Ebenezer Byrd. Clearly that couldn't happen. We can proceed.
Right.
He makes no findings with regard to the other allegations at all. Would you agree that there's nothing in here about any of the other allegations beside the texting with Ebenezer Byrd? Then the trial moves on and proceeds.
Actually,
so the argument from defense counsel's side is that determination that these allegations were not credible and the court did not need to further investigate or do anything more were based almost entirely on the texting with Ebenezer Byrd portion of the allegation.
I would disagree, because after he questioned the juror, she denied everything. He then sent her back, and he had a colloquy with counsel, and counsel, went through and said what they needed to say. And he said, and that's what he said, well, I find her to be credible. I find her to be sincere about her actually denying everything. And then I think Judge Oxley used his common sense.
Part of the issue is when you say that she denied everything. Mm-hmm. What's everything?
She denied all of Judge Oxley's questions.
I get that, but the content of those questions is at the heart of the case. Whether they went to the heart of the issue when you questioned her.
I think if you look at the way that they're worded, Your Honors, I think the first question, anything happened throughout this trial that would affect your answers to those questions. And so I think he was trying to get at has anything happened? Are you texting with anybody or anything like that? In terms of posting or newspaper articles, is there anything outside of this courtroom that you have been in contact with? Again, outside of this courtroom, meaning people at work, Googling, anything like that. He says anything outside of this courtroom.
That could imply information received.
Sure.
But the allegation isn't that anyone talked to her, but that she was making statements.
Right. And one of the defense attorneys, it was a defense attorney for Mr. Jean-Baptiste. And this is on the transcript of February 19th, 2019. I'm on page 129, and I'm going to go to line 6. Or if we go back to page 128, Mr. Bailey, who was represented, he says, because again, Judge Oxley said, anything else? Anybody have anything else? And Mr. Bailey says, I'd like to ask that she be further questioned. And the questions that she has spoken to anyone at her job specifically about the case, I think that's a question that should be asked, and I think it's innocuous enough. And Judge Oxley says, okay, I'm satisfied at this point with the inquiry that I made. My concern is to make sure that we have a fair and impartial trial with a fair and impartial jurors. I specifically asked her whether or not she has come into contact with any outside information. Her answer was no. And as I indicated, she was about as candid and straightforward as she could be. And so he was asked about that. And Judge Oxley went back to his credibility finding. He went back to the no, and he went back to the credibility findings. And he said, I believe her.
And again, that question is incredible. I'm not understanding how that question goes to the specific allegations. So the question, and in terms of any postings or newspaper articles, is there anything outside of what's been in this courtroom that you have been in contact with? Sounds like your argument is that covers everything. That covers whether she talked to anyone, that covers whether she Googled, but the introductory clause to that question says, in terms of postings or newspaper articles. In terms of postings or newspaper articles, have you been in contact with those things? That's the question. It's not, I don't think a reasonable reading of that question or hearing that question includes the judge is asking me about everything in the universe that I could have read, Googled, spoke about. I just don't think that's a reasonable interpretation of that question. But the introductory clause begins in terms of postings or newspaper articles. And is there anything you've been in contact with?
And that's us reading the cold record. But we have Judge Oxley that specifically was asked that question, and we have what he thought about that. He specifically said, I asked her if she had any outside information, and I'm satisfied with that. That is the question that he asked. That is the way that he asked it. And that's what, and so we have on the record that credibility finding. That is the question that he had. I mean, we can speculate, but we have actually Judge Oxley, when there were certain questions that the lawyers wanted him to ask, where she worked and where she lived. And he asked those. One of the lawyers wanted to ask him about the text. And he said, well, there's a fine line we've got to draw here because I don't want to interject taint. And so you have a situation where Judge Oxley's asked her a question. She said no. And so the follow-up question is, are you sure? Is there any other outside information? I mean, she said no.
You agree that all of this happened
that is, I don't, where's that follow-up question?
I don't see that.
I'm sorry?
What are you reading from in the transcript?
As far as Judge Oxley?
Follow-up question.
Yeah.
But Judge, what I just read to you?
You indicated that he followed up with, are you sure? Is there anything?
No. I said, what was he supposed, what could he do? Follow up with, I'm sure. I'm just saying. We could speculate that he could have done that, but she said no.
Right. She said no to that question, which was not a specific,
she said no to all the questions.
Which was not a specific question to the allegations. And that's why we're here.
Right. There wasn't specific. He specifically told us on this record why he did not want to ask specific questions. And I think that should be given deference. He told us why he didn't want, it wasn't that he didn't do it. It wasn't that he was not, it wasn't that he was derelict in his duty as the gatekeeper of this, or that he wasn't investigating this claim as the defense suggests. He did. He did. As soon as this came in, he took care of it. What we have here is Judge Oxley specifically telling the lawyers and then this court on review why he did what he did and why he started with those broad questions.
Why is it an effective way to question a juror in front of all the remaining jurors? So it's a full courtroom. He doesn't ask this during lunch when the room is clear and only counsel is there. He doesn't ask this during any break. I'm sure there were breaks in trial. All the jurors are sitting there. He has one juror come up. How could it possibly be an effective way to investigate this? Doesn't that lend itself to only like 2 questions because you don't want all the rest of the jurors to be wondering what's happening? No, I think that in itself assume that you're not really going to investigate and ask specific questions.
I think the jurors, and they're always used to sidebars. Sidebars happen all the time. The noise goes on. People go up to sidebar.
But with an individual juror.
Right, an individual juror. And this had happened before. We had scheduling, there were scheduling issues in the trial where a juror had, and Judge Lee said, you stay behind, I'm going to talk to you, whatever. Again, this was like
happened here, right?
I'm sorry?
You said when there were scheduling issues, one juror stayed and everyone else left.
That's
correct. Now this person is being asked these questions in front of all the other jurors, correct?
Right, because Judge Oxley got this right before lunch and they broke for lunch. And he
but could have let the jurors
but he had
break for lunch and kept that person behind.
No, because he hadn't talked to the counsel yet. Judge Oxley was in the middle of trial when he got this email from his clerk saying, something's going on. Because as you can see from the email, the secretary said, can Can you email or write it down? Do you want me to pass him a note informing him that you have more information? He was in the middle of testimony when this came through, okay? And so he had to have an opportunity to talk to counsel, and RD, it specifically says you have to, you have to discuss things with counsel. And
Correct.
so
And once he spoke to counsel, I'm still not understanding.
once he spoke with counsel and they came back from lunch, he then pulled the juror and asked him right then and there. The jury came back into the box after lunch and he immediately pulled juror 8 out. It would make no difference, as Justice Patterson said earlier. I think it would be more prejudicial if everybody's back in the jury room and the person who's responsible for the jury, because there's usually one person that walks everybody around, the one person jury says, hey, juror number 8, I need you to come out here and talk to the judge, or I need you to step out of the room for whatever reason. I think that is more jarring because everyone in the room is going to be like, well.
But again, as you just mentioned, there's oftentimes during the course of a trial where the juror does speak to the court and the attorneys separate from everyone else. If there's scheduling issues or other issues that come up during the course of trial.
Right, but
So
they
it's
take them
not
from the
necess-
box.
but
You don't
it's
take them
not
from the room.
Always, it's not necessarily out of the ordinary. If they're not in the box, then they can speak before the trial day starts, before they go back into the courtroom. I don't think that that's something that's completely out of the ordinary.
I don't think that our law states, and this court has said, that the investigation must happen and the questioning must happen in the presence of counsel. I don't know any case law or anything that this court has said or any other court has said that where it takes place is dispositive. I think, again, it's judicial discretion. I think the judges, when judges have relationship with juries, I know when I was in trial, our judge used to bring donuts to the jury and things like that, and so Judge Oxley made a real-time decision to bring this juror. He didn't want to pull her. It would seem weird. I think it would seem weirder that you pull this jury out after lunch, because the jurors know that counsel and the judge talk at breaks and during recesses. And so we had a lunch break, and then all of a sudden you bring juror 8 you don't go back to testimony, but you bring juror 8 from the jury room and bring her in front. And so whether or not, I just think that would be more jarring than just simply calling her from the jury box, putting the noise on, having a quick discussion with her like it happened here. And again, it wouldn't have been quick had she admitted or had there had been something that Judge Oxley needed to follow up on. But I don't think that's dispositive here. I think it's the conversation needs to happen. The investigation needs to happen. To answer your question, Your Honor, I don't think that where it happened is dispositive in this case.
Judges generally can manage their courtroom. Your point on this particular issue is how it's done. It's generally in the discretion.
Yeah, and maybe the judge, and again, Judge Oxley said, as far as going back to chambers, I've never done that before. It's just was his policy that he didn't, again, you have.
I think we have your answer on this point.
Okay.
A couple more questions and then we're going to try to draw the argument to a close.
Okay.
Please.
One quick question.
Sure.
What harm would there have been if he said to her, have you already predetermined guilt?
I think you would have prejudiced her. I think she would have gone back to the jury box going, why would it? She already asked, why do you ask? She was already puzzled as to why she was getting these broad general questions. If you zeroed in and said, have you predetermined the case? I think it would have gotten into, well, what do you mean? I think you would have gotten into really just, we want our jurors, after this situation, Judge Oxley did not find her to be tainted. So she went back to the jury box. We want the jurors, when this questioning and stuff happens, to go back to the box and listen to the testimony and listen to what's going on in the case. We don't want the juror going back to the box going, gee, I wonder, did somebody say something about me? Why would the judge think I predetermined the case?
She was already going back to the box thinking, why am I even up at the sidebar? Because she asked the judge that question.
She did.
But he's looking at this email. Mm-hmm. And it does say that she already decided the case.
He also knew that it could be fabricated. He knew that it was inconsistent.
What harm would there have been at that point if he had asked that one important question?
Your Honor, the state would submit that it would have prejudiced her. It would have prejudiced her. I think it would have prejudiced her if you asked that question. If you asked her if she predetermined the case, she would be wondering, whether or not, again, why would somebody be asking you that?
And then
have you ever talked about this case at work? It's pretty innocuous. It doesn't say she's done something wrong. She knows she's not supposed to do it.
I think, Your Honor, again, I will go back to Judge Oxley's explanation that he specifically said on the record why he didn't ask that question. However, to answer your Honor's question, I don't think there would have been a harm to ask that question.
I mean,
I
that,
think it
that
was-
would either end the inquiry, if she said, no, of course not, I've been listening. He could decide she wasn't credible, or it would have led to more, and maybe it ends after a few more questions, but there would be a little clearer record. I'm thinking of, obviously, of the next case.
Sure. And again, I think the next case, it's a case by case analysis. The next case, we may have an allegation that's not as dubious as this one. And I think Judge Oxley, in making real-time decisions, decided that he wasn't going to do anything specific unless or until the juror admitted something or gave him an answer that required him to go further. And this juror did not, the questioning and her answers did not lend that ability. She denied everything.
We say there was an abuse of discretion. Do you object to a remand for the sole purpose of finding juror number 8 and having a limited hearing?
It is the state's position that there is no abuse of discretion here, and that's what this court should find. However, in lieu of reversal of the conviction, the state would not object. However, I would say that I think it's State versus Basaka, and I know it's an appellate division case, but it cites to State versus Harris, which is a case from this court, and it says in order to do a post-verdict hearing with a juror, it has to be extraordinary circumstances, and there needs to be a strong representation that the defendant had been harmed by the juror misconduct, and I don't believe that this case fits in that.
If that were to happen, would the state want to not that the state would investigate, but would the state want an investigation to go on as to who Ms. Worthy or Wordy or whomever might be?
Certainly. If we could find her, I mean, it's a friend of a friend.
Who might have a phone number.
Who might. And again, from this record, again, I caution this court, I implore to this court to recognize what Judge Oxley was faced with at the time, that we didn't really know who it was and the inconsistencies in the tip.
I want to avoid some of the repetition. Justice Hoffman has a question, and then we're going to move on to the next.
Counselor, I'm not entirely sure that Judge Oxley was as careful or as premeditated, respectfully, to the judge. And the part of this that gave me pause hasn't come up. And it's right before juror number 8 comes up. And Mr. Ward, who represents Spraulding, says, Judge, I think you should inquire about some of the specific allegations, especially that she talked to other jurors. And Judge Oxley said, I will ask whether or not she did. But he never asks that question.
He did not.
Doesn't that give you pause?
It doesn't. And the reason why is because I think her unequivocal denials, he decided not to ask that question. I mean, we don't know, I'm speculating, but in reading this record and realizing that, I mean, juror number 8 didn't hesitate. She didn't, she unequivocally said no. She unequivocally said no. And then when asked if she could be impartial, she said she could. I can.
But unequivocally said no to questions that didn't relate to whether she talked to her other jurors about it. Right? I mean, we keep going back to the no's, but those no's have no relation to the specific questions that we're asking, including the specific question Justice Hoffman appropriately pointed out that the judge said he would ask.
There's no doubt that
the no's to the other question have nothing to do with the question he said he was going to ask.
Absolutely. There's no question and that the questions were broad. The state would submit that the questions were broad for a reason, and Judge Oxley put that reason on the record.
Counsel, anything you'd like to close with?
We ask this court to affirm.
Thank you. Mr. Galemba, help me, because I envision that we will get through this argument with rebuttals by 4 o'clock. Please go ahead.
What time is it now?
It's 3:35 on the clock behind you. Go ahead.
I'll do my best, Your Honor. May it please the court, a one-size-fits-all approach to the trial court's handling of allegations of juror taint is not appropriate because each claim in every trial is different consistent with the traditional deference this court has afforded trial courts in the manner of handling juror matters. The Attorney General urges that the manner of inquiry into allegations of juror taint should lie within the sound discretion of the trial court based on the trial court's unique advantages, including its feel of the case from presiding over the case and its ability to evaluate the affected juror's credibility firsthand. Here, based on the totality of the circumstances facing Judge Oxley, he properly exercised his discretion in his tailored questioning of Juror 8, and there are 6 case-specific factors I'd like to go through why the way that this judge framed the questioning was appropriate. First, the tip itself was double hearsay with an unnamed coworker as the middle declarant. Second, underscoring this significant attenuation, there's a disagreement on exactly what Miss Wordy said. If Miss Wordy said that Juror 8 was texting with Byrd, that's inconsistent with the claim that she had prejudged guilt. But no one, including defendants, agree exactly about what Miss Wordy said and what the significance of it is. Third, the only independently verifiable information Miss Wordy provided, the name and employment of Juror 8, was easily known to defendants or could easily be determined from the defendants or from anybody sitting in the courtroom during jury selection. Fourth, there's the oddity of the call going to
Can I pause you on that?
Sure.
Do you know whether the name of the facility, the healthcare facility was just talked about in open court?
Well, at the remand hearing, the assistant prosecutor specifically stated that that was mentioned by the juror during jury selection. That's at page 14 of the remand transcript. He stated that the name and the place of employment was mentioned by the juror during jury selection. I would say that even if it was not stated by the juror, you could determine that in about 5 seconds if you know the name of the person and you know that they're a nurse and you know they're in Monmouth County. You could probably just put that in Google and it pop up in 5 seconds. So I don't think that's a particularly hard determination to make either way. I don't think that's fact determined or outcome determinative. Getting back to the list, fourth, the call went to the public defender's office. And besides that being an office associated with the defense, it begs the question of how the caller even knew that Byrd's counsel was assigned through the public defender's office, which is not public information and suggests that whoever called had inside information. Fifth, there was no apparent follow-up by the public defender's office. This call was made to them. It was within their control. There was no attempt to obtain an affidavit or anything else to confirm the truthfulness of what Miss Wordy had said, which is consistent with what she said, that she only wanted to provide, she only provided a partial name and didn't want to be contacted any further, suggesting that.
Counsel on the other side suggests that it wasn't their responsibility to follow up and that the trial court was required to follow up. Is there any case law that has discussed anything like that?
Well, certainly in the post-trial context, oftentimes it comes to the court through affidavits that the defense provides. And in terms of specific case law, I'm not aware, but RD only requires the judge to question the juror. It does not require this expanded investigation. Typically, the court's not in the position, it's not an investigatory body, it's an adjudicative body. But there's not even any verifiable information on this record that the judge could determine who this caller was. There's no indication that she left her phone number. We don't even know the actual name of the caller. So there's nothing where the judge could just simply call the caller directly. And the final reason is that there's a heightened risk of tampering here, given the evidence that each defendant had already tried in some way to frustrate the truth-seeking function, and two had actually been charged and ultimately convicted with tampering. So because of the real risk that somebody was trying to engineer a mistrial, Judge Oxley was clearly trying to walk a fine line, as he said, between detecting taint and avoiding accidentally prejudicing the jury and injecting taint. If
somebody had been engineering a mistrial, wouldn't it have required juror number 8 to say yes to some of these questions? And the fact that she said no, and the outside information was that she wanted to burn them, imply that the opposite of the defendants being involved in the malfeasance? I mean, that seems to be what's been implied, I think.
I'm sorry, I might not understand your question, but the fact that she denied the questions that the judge asked would suggest that they were not true. And that's why the judge did not go any further with the questions.
But it sounded like you were saying there was a heightened risk of tampering involved, meaning that who is doing that and how were they trying to execute that plan from your understanding?
So anybody in the courtroom who has this information could call up and provide that information.
You're not saying that they actually had communications with juror 8. You're saying that there's a possibility, although there's no indication really here, that somebody may have had something to do with the call.
Exactly.
Is that what
exactly the call, not the contact with the juror.
Meaning anyone could have been pretending to be Miss Wordy.
Yes, and so not tampering with Miss Wordy, but tampering with the trial itself.
Counselor, this is a comprehensive and rational, logical list. Wouldn't we be in a different place if the judge had put all this on the record at the time?
Well, the judge did put a number of reasons on the record, both at trial and at the remand hearing, as that go to his evaluation of the veracity of the tip itself. He had, as had been discussed earlier, the fact that there's this texting allegation and Mr. Byrd had been incarcerated, but also the judge stated that this was something that was an outside concern that came through the public defender's office. So he considered the fact of how the information came to the court's attention in the first place. He also considered the fact that Miss Wordy's name he didn't know that name. He hadn't heard it before. He hadn't heard it since. And by the way, nothing ever happened with this again after this interaction with juror 8. No other juror brought it to the attention of the court that juror 8 had been discussing the case or had outside information, despite their instructions to do so. And the judge also indicated that he didn't want to go too far because all of this may have been fabricated. So he gave multiple reasons why he was skeptical. He didn't specifically say he was skeptical, but that's the fair implication. That's why he stated he wanted to walk a fine line between prejudicing the defendants and sussing out any taint.
Counsel, we've asked some fairly focused questions looking at the exact text that was used in this inquiry. Take a half step back. The 4 relevant questions that the judge asked, is that a best practice that you would commend in other cases?
Well, so if we're talking about abuse of discretion standard, perfection's not the standard. Now, there probably could have been 1 or 2 more questions asked without crossing that line into tainting the juror. But because of the totality of the circumstances that the judge had to consider in questioning juror 8, the fact that he had questions about the reliability of this information in the first place and not wanting to cause a situation where he has to excuse the juror. Because of that reason, his questioning was carefully selected to not reveal too many details about the tip. So as I said, there probably could have been 1 or 2 more questions asked, but that's not the abuse of discretion standard. It doesn't demand perfection.
Could you identify what those 1 or 2 more questions are?
Well, it had been asked whether the judge could have asked whether juror 8 had discussed the case at work. 1 point on that, the judge, when he asked about outside information, including newspaper articles and postings, it's the Attorney General's position that does touch on that question of whether she's discussing the case, because the allegation itself that Ms. Wordy made is that she was Googling the case, showing articles to, and talking about it with other people. So the discussing the case with other people includes showing articles, and she's denied now that she has been looking at newspaper
But
articles.
you're saying that from the perspective of someone who knows what the allegation is. She doesn't know what the allegation is. She's simply being asked with regard in terms of posting her newspaper articles, is there anything outside what's been in this courtroom that you've been in contact with? How does she know that that includes talking to other people, talking to people at work, Googling the case?
Well, she's denied that she's looked at newspaper articles. She's denied that she's looked at postings.
What does that have to do with talking to other people about the case?
Because the allegation that she's talking to
Does she
other
know what
people-
the allegation is when she's being asked that question? No.
She doesn't know that, but it's
So someone being asked that question, how would a juror or anyone interpret that question to be asking them, did you also talk to other people about this case?
I don't think the juror had to interpret it. The judge knows what the allegation is. And if she's denying that she has seen any newspaper articles, then she's not showing newspaper articles. If she hasn't been looking
But
at,
is she talking to anyone about the case?
well,
Does
and
that question cover that?
that particular question, no. Whether she's discussing the
Okay.
case, no.
Would your argument be stronger if the judge had asked, is there anything or anyone? ... That's not what happened here, though.
No, it's not. But, and again, the Attorney General's position is there could have been another way to do this. There could have been another couple questions asked. But because of what the judge had to consider in making sure, this was a murder case with three defendants who have all been accused of tampering with witnesses. So he's worried that he's understandably worried if he continues to ask this juror questions after she has, in his opinion, credibly denied the allegations he's already asked, that there's going to be a risk that he's injecting that very taint that she has at least in part denied. So the initial answers that she gives, that can inform how far the judge goes with subsequent questioning.
Could the judge have simply asked, have you predetermined this case? A simple question.
He could have asked that. I think.
Would there have been any harm in doing that?
I think the issue is, and I think he could have asked that, and if he had, we'd be arguing that there was no abuse, just like we're arguing there's no abuse with him not asking that. I think the risk is if you keep asking more questions after the juror has already denied one specific part of the allegations, then you get to the point where the juror is now speculating, and this juror was already concerned about why she had been brought up there and puzzled. So, which the judge.
It also does that one, as opposed to, we've been talking about this at work, starts to get into an area where she starts talking about what she thinks about the case.
It could. It goes into the juror's deliberations, but beyond that, it'll also potentially makes the juror feel that she's being targeted, because if you ask more questions, then it raises the specter of, well, somebody's been saying I did something, and she's already denied part of the allegations and has maintained that she can be fair and impartial. So there's a significant risk in continuing to ask questions. Now, as I said, that question probably could have been asked, but it's not an abuse of the judge's discretion based on what he already knows about, or what he already has his feelings about the tip itself from his feel of the case, and based on the questions he's already asked and his evaluation of her credibility. And this is not the first time he's seen Juror 8 testify. He saw her at jury selection. He's watched her through trial, and then even while he's asking the questions, he's watching the juror as she responds, as he's asking the question. So all of these things are why we give judges discretion, and he made very clear and repeated credibility determinations that this was a straightforward, candid juror.
I'm sorry to rush you. We're at 15 minutes. Is there anything else you wanted to stress before you conclude?
Yes, there are a couple of things. Justice Fascielli, you had suggested asked what factors that could be considered. I agree that the seriousness of the allegation is a factor. Also, the source of the tip and the content of the tip itself, who the complaint was made to, or how the complaint came in, whether the tip contains specific verifiable information, and then generally the judge's feel of the case. In terms of, I wanted to mention briefly before I forget, the court has asked about the remedy. I think, and the Attorney General's position is clearly that there was no abuse of discretion. But if your honors harbored any doubt about this juror, then I think this is a particularly appropriate situation where you could do a remand. And I'd refer to Bisaccia because in that case, the appellate division found only 6 years had passed since the trial, and the judge was still sitting on the bench. It's my understanding Judge Oxley's still sitting on the bench, and it's been 6 years since trial. Now in Lofton, this court had declined to remand for that hearing, but I think Lofton is a different situation because in that case, 13 years had passed. And also that case involved more of what the juror who was allegedly racist had said to other jurors. So here you would only need to call juror 8, because if the allegations were true and juror 8 presided and deliberated on the case, then that would be the end of it. You don't even need to get into the remaining jurors. So it's just one juror that would have to be.
Would we have to, would the trial court on such a remand have to try to track down Ms. Worthy or Wordy?
I believe that would be in the discretion of the court and also the parties. That might be something that the state wanted to do to track it down, if she can be tracked down, to lend itself to whether it's to determine whether it's verifiable, whether the tip is even verifiable. But I don't know that I think it would be more, I see it more as recalling the juror and questioning the juror. And then one other point I wanted to make is that besides this particular juror and prejudicing this particular juror against the defendants by continuing to ask questions, there's also a risk if the court were to say that there has to be this fulsome inquiry every time. There's also a risk that it will be open season on jurors and witness tampering on juror tampering in the future. If a defendant or somebody associated with the defendant knows that they can just call and make some allegation, and then the juror has to be asked specifically about those the allegations, then there's a risk that this is something that could multiply. So I think that the questioning has to be tailored to the specific circumstances and the veracity of the tip.
Thank you, Mr. Columbus.
Thank you.
Mr. Kirsch, Mr. Burrows, you both asked for rebuttal. Ms. McLean, you didn't, but I think you meant to because you referred to it in the middle. You can each get 2 minutes without us questioning.
I'll be very quick.
Oh.
Two quick things. The duty from the case law is to ask specific questions that go right to these allegations. You heard the state argue over and over and over again, praising the judge's broad questioning. The broad questioning is the problem. And please keep that in mind, that the abuse of discretion standard relates here to the failure to be specific, not to pick at individual specific questions that were asked. Specific questions weren't asked here, and that's the problem. It's the broad approach that is the problem. The second part of this is, I just want to emphasize Bisaccia is the outlier, the extreme outlier in terms of ordering a remand. It's the only case that does it. Bisaccia also says when you order that remand, the burden is on the state beyond a reasonable doubt to prove that there was not juror taint. If the evidence isn't there, you can't find the juror, you can't properly investigate this, that's on them. I have nothing else.
Thank you, Mr. Kirsch. Ms. McLean, did you want to give a rebuttal?
Reiterate Mr. Kirsch's last point about the remand. Also regarding the remand, asking a juror 6 years later, after she's returned a guilty verdict, how did you feel on day 10 of a murder trial? is going to not produce terribly useful information.
May not be the best question.
But if the answer is, have you predetermined guilt 6 years after she returned a guilty verdict, it's going to be hard to get at that allegation at this point in time.
She
And for
might
that
remember
reason,
whether she talked to people at work.
that perhaps could be investigated. Regarding the question as to finding Ms. Worthy, yes, OPD has caller ID. I would be shocked if it still exists at this point. So again, a remand is not required, but if there is a remand, the burden is on the state to prove the absence of taint. And if there's any question remaining, at that point, the convictions must be reversed.
Thank you.
Thank you.
Mr. Burrows.
Briefly, just to rebut the state, I would ask the court not give deference to this trial court's factual findings. I'm only going to cite to the record. I'd ask the court to look at the voir dire on February 19th, 2019, page 129. The key to this case is text messaging. It's from that belief that was fabricated that led this specific trial judge to a cascade of errors. And here's what the judge says. Information, as I understand it, had originally stated out that the juror was texting Ebenezer Byrd and his friends, and clearly that couldn't have happened because Mr. Byrd had been in custody for quite some time at this point without access to computers or texting or Facebook or any of those other things. So I'm satisfied at this point we can proceed. Then on page 24 of the remand hearing of September 10th, 2020, the judge makes the same mistake again. He says on page 24, line 15, he sums up the allegation. The allegation simply was that she'd been texting and talking about the case, and I was satisfied based on her candid response at my questions that she had not happened. On page 101 of the appellate division decision, the appellate division says that the judge believed the allegations, quote, may have been fabricated because the juror, quote, was texting Ebenezer Byrd, which couldn't have happened because Mr. Byrd had been in custody for quite some time. That wasn't the allegation. That was an email from Stephanie Blase to the judge's secretary. But when the judge sent his own clerk to talk to Stephanie at OPD, the texting allegation was never made. But the judge focused on that. He couldn't believe it could have happened. So all the remaining
There's
allegations.
nothing indicating that was withdrawn. It just wasn't mentioned again. So it is part of the allegation. The judge is part of the picture that he was given. And nobody ever said, that I understand, tell me if I'm wrong, that Stephanie says, no, she misspoke or somebody misspoke or that was never said.
Well, the judge's court clerk said in her email, I went to get more detailed information. I spoke to Stephanie and here's the three allegations.
Right,
Yes.
but that doesn't mean that part of the allegation was removed from the case somehow.
I think it's reasonable to infer, though, it was not made by Stephanie to the court's clerk. Otherwise, the court's clerk would have memorialized that. Okay, that's all I have.
Thank you, counsel. Thank you to all counsel for the helpful arguments. We'll take the matter under advisement.